Hello, can everyone hear me? Can you all hear? If you can't hear, please put up your hands and let me know, because there's nothing worse than not being able to hear someone from up here. I'm Rita Goldberg. Hello to all of you. What an amazing turnout we have tonight. And I bring greetings to you on behalf of the whole Cary Lecture Committee and also from the Cary Memorial Library, our co-sponsors, both, of course, here in Lexington. And now I have to make a lot of boilerplate announcements, so please be patient, and they are worth making anyway. Before I go any further, please notice the exits, the emergency exits. They're behind you and on the sides here. I hope that is the only mention of fire we will have, because although this is called a fireside chat, there is no fire, and I hope it stays that way. We're able to offer a series of 4 free lectures each year, wholly supported by the Isaac Harris Cary Fund, which was set up by 2 sisters, Susanna Cary and Ellen Cary Farnham, in 1929, to help educate the townspeople of Lexington, who at that time, this was mostly a farming community at that time. They also gave our town this beautiful hall, Cary Hall, for these lectures and for many other events, including town meeting. They belong to a different branch of the same Cary family that gave us our library. So it's very redundant in Lexington. It's all Cary all the time. The lecture tonight is the last in this academic year's cycle. It's also the last of 3 lectures in honor of the 250th anniversary of the Battle of Lexington. You may remember that the other 2 lectures, especially designated, were Professor Philip Deloria last October and our own Lexington Symphony director, Jonathan McPhee, in March. You've gotten the flyer that went out to every household after Labor Day in a slightly different format this time, but still mainly yellow, which is this characteristic color. These are, I can't emphasize this enough because I've had so many questions about this. These are announcements, not tickets. We have not used tickets for well over a decade now, so please remember that. You can come without anything on your person except clothes, I hope. Each lecture is well publicized in advance and is on our website, carylectureseries.org. And please look for them in the mail, again, just after Labor Day. We have most of our speakers lined up, so please be attentive and you'll see who they are. Before I introduce the Honorable Stephen Breyer, because I have to say this too, I'd like to thank a lot of people, the director and staff of Cary Library, for their steadfast partnership and their beautiful posters. Special thanks as well to Jonas Miller, Lexington's Director of Communications, for including us in his weekly calendar of events, to the Lexington Observer for carrying our announcements, the Department of Public Facilities, who handles our sometimes challenging bookings, and as always, with particular affection, we'd like to thank the staff at Batten Auditorium, which this is, in Cary Hall, especially to Kyle Walsh and Vincent Leroux for their long, patient hours working with us. Now, finally, it's my honor to introduce retired Justice Stephen Breyer. I'll try to be brief, although his distinguished record is long. At present, he's the Byrne Professor of Administrative Law and Process at Harvard Law School. After a stellar academic career culminating in his graduation from Harvard Law School in 1964, he served as a law clerk to U.S. Supreme Court Justice Arthur Goldberg. Excuse me, I have a cough which has come on just now, so I hope you'll pardon me. He was a professor at Harvard from 1977 to 1980 and held numerous public service roles in the 60s and 70s, including as a member of the Watergate Special Prosecution Force and as special and then chief counsel to the Senate Judiciary Committee. In this position, he worked closely with Senator Edward Kennedy. President Carter appointed Breyer to the U.S. Court of Appeals for the First Circuit in 1980, which is our circuit, right? The First Circuit is Boston, right? On which he served from 1980 to 1994. He was chief judge from 1990 to 1994, chief judge, I should say, and then when President Clinton nominated him, Judge Breyer became an associate justice of the Supreme Court. He began his tenure in August 1994 and served until his retirement in 2022, if you can call his time since a retirement, which I doubt. He's the author of numerous books and publications. And just for interest, he also has an active interest in architecture and is involved with the Pritzker Prize for that, and was a member of the Army Reserve in his youth, serving on active duty for 6 months during college. I think we're all hungry for Justice Breyer's wisdom at this especially stormy moment. I was sort of hoping it would still be stormy when I said that, but anyway, it's stormy enough. Justice Breyer, if you'd like to come up, thank you very much.
Thank you. That was a very nice introduction. And thank you all for inviting me here. Very nice to be here. And I promise I'm never going to say which Lexington or Concord was where the embattled farmers.
Well, I have all these questions for Justice Breyer. I can't really see you because of the lights, but I know all of you do too. And actually, Justice Breyer instructed me on the first question, so I can't ask the one I had on my sheet. I'm going to ask the one you asked me to ask you, which is, what do you do on the Supreme Court? Am I right? Is that the right question?
Perfect.
Oh, thank you.
I thought probably some people here would not be lawyers. Possible. You realize we have a population of 330 million. 329 million are not lawyers. So, hard to believe. But I thought what do we do on a Court of Appeals, the Supreme Court? I found the perfect, because I like to talk to 7th graders, 8th graders, anyone really, 9th graders, high school. And you talk to 7th graders, they're all looking out the window. So how do you get their attention? Well, I said, I found, which is true, in a French newspaper. You're interested in France. Well,
I know what you're going to say, but I'm not.
You do?
Yes, because I read your book. I read your book. Go
Good.
ahead. I won't
That's
spoil
very
it.
Good. No, well, it is true it happened in France. There was a biology professor who was traveling from Nantes to Paris, and he had 20 live snails for his class in a basket. And the conductor came up and he said, what's in the basket? He looked, he said, do you have a ticket for the snails? The professor said, what? This ticket for snails? That's ridiculous. The conductor said, read this. It's the fare book. It says no animals on the train unless they're in a basket and you have a half-price ticket. The professor said, they're not talking about snails. They're talking about dogs or cats or maybe a rabbit. What does it say? Says the conductor. So then I go to the class and say, who are all looking out the window, what do you think? And that's the last word I have to say. Because they're all arguing with each other. Some say, well, of course a snail. Well, what about a caterpillar? What about a mosquito? Mosquito, you have to pay for a mosquito. What? Are you kidding? Is a mosquito an animal or isn't it an animal? Okay, there we go. Now, you know what the Supreme Court does. It's true. It's true. I grant you the words might not be animal. The word might be freedom of speech.
That's almost the same as a snail, isn't it?
Well, sometimes it might be freedom of right to bear arms or something.
Right.
But you get the idea. And we only take cases, almost only, if the lower courts have come to different conclusions about the meaning of the same phrase in a statute, a federal statute, Congress, or this document, the Constitution. Because if they all think the same thing, what need is there for us? They're good judges. And if they think different things, though, it should be uniform throughout the nation, so we'll take it. Now you know what we do. There we are. Question.
Tchaikovsky. That's hard to follow up on. I'm going to come back to your book just quickly, if I might. Not the snails, though. Just about, well, I'm a literary person myself, as we discussed at dinner, and what puzzles me, you have many terms in the book. You talk about pragmatism, textualism, and originalism, which you tend not to be so sympathetic towards, though you are very balanced in the way you talk about them. And then you talk about your own inclination towards pragmatism and what you call traditionalism, which surprisingly is not the same, not close to originalism and textualism. Could you tell us a little more about that? Because as a literary person, as I said, I know that originalism is supposed to be, isn't it? That they try and establish what the intent was when the Constitution was written.
Yeah,
and as a literary person, I can't imagine even trying to do that. So I'd love to hear your thoughts on that.
Well, I went to law school at a time, and I think it's probably still true, when people admired very much Justice Holmes and Brandeis and Learned Hand and Cardozo, and in the school there were Hart and Sachs teaching their legal philosophy, and that's really what I mean by that. I mean, the words in the text are the first thing you look at. If the word is carrot, that does not mean a fish. No, it doesn't. Some might try, but it doesn't. All right. But very often, you don't know really. It's somewhat ambiguous. It could mean any of several things. And there are other things you can look at to try to help you decide what this word that you're looking at now, what does it apply to? For example, it says police officer. Does that include German police officers? Probably not, you say? But the words themselves won't tell you. So look to see, someone wrote these words. And this document, we know they wrote it. And they wrote the original document, 1787, 88, 89. We know that. And people wrote the words in Congress, and they had something in mind. So let's find out. They used to say in your favorite century, the 18th century, right here, the judges would say, what was the mischief that Congress was trying to cure? So I'd say, let's look at that. It won't always tell you. Let's look and see if you had decided this way or that way, will you cause real trouble, or will you help? Or let's look at the history. Or what were the big political issues then that they were trying to solve with this? And let's see how that all fits in. In other words, people wrote this. What would they have in mind? It's hard to say. And there are usually 2 or 3 things that are possible, and you look through those different things and you try to figure out what will actually work. And experience is such in any profession that if you spend, as Joanna did, years at Dana-Farber, or you spend years as being a judge, you begin to get a feeling for the job, for what these words might mean, for what are the things you might look at. All that's part of it. And the word pragmatism was made up by not me, it was made up by the publisher. He liked the word. I think it was better in French. You like the French. In French, it's the Constitution of the United States, la lettre ou le texte, the letter or the text. And of course, I think, no, the letter or the spirit. I say I don't,
That's
my French disappears quickly. The letter ou l'esprit. Okay, letter or the spirit. And I think, of course, the spirit. What's the theory of it? All right, now, you want to know what textualism is?
Yes, please.
You may be the only one here who really wants to know. But, but
well, we have lots of other things coming.
Right, sometimes about, I don't know, 20, 30 years ago, I used to say, it must have been Ed Meese, I don't know who it was. They invented this thing, textualism. And textualism, Nino Scalia wrote a book about it. He was a good friend. I liked him very much. We used to go to places, schools and universities, law schools, and we'd debate together, and it was sort of fun, and we enjoyed it. But he wrote, don't look at anything but the text. Just look at the text. Or originalism just meant, if you're talking about the Constitution, the text is usually, or quite often, very abstract. So look at what the words meant to the people in 1789 when they wrote those words. Don't look at these other things I've been telling you about. So I said, why do you want to do that, Nino? And he says, I'll tell you why. First, here are some promises he's making. And he says, here are the promises. 1, it's easier. Use it. 2, you'll get approximately the same thing all over the country. 3, Congress will like it because they'll know what's going to happen to the words they're writing. 4, it will prevent, he doesn't look directly at me, but he'll say it will prevent judges from substituting what they think is good for the law. You see? Those are the 4 promises. So when we debate, I'd say, Nino, you
Am
can't
I Nino
do
now?
that.
I'm Nino now?
No, you're not.
Oh,
But
good.
you might be interested, though. I said, Nino, George Washington didn't know about the internet, you know, freedom of speech and the internet. He didn't know about that. And Nino would say, I know that. Then he would say, but the applicable thing are the 2 campers. So I said, what are the 2 campers? He said, the 2 campers, one sees the other putting on some running shoes. Why are you doing that? There's a bear in the camp. You can't outrun a bear. Ah, yes, but I can outrun you. Then he would say, Stephen, I think you are sincere in what you do, and I think many people try to do it, and I know there are problems with the way I do things, but your method is so complicated, and the ways you go about it are so complicated that you're the only one who can do it, if you can. And I would reply by saying, well, Nino, I understand that. It is somewhat complicated. It is not rocket science, the law. It is, feelings are part of it. A heart is part of it. It's not just mathematics or anything. But if we take your system of just looking at those words, we're going to end up with a constitution that nobody wants. So when will we find out who's right? 40, 50 years from now, maybe. I don't know. I don't know. But I say, well, why does the textualism not work? You want me to bang on like this? Yes?
Well, as long as you want to.
I'll say,
I have other questions.
I'd say textualism. We have a case. Here, I found the easiest case with textualism I could find. I was looking for some to put in the book. So I found an easy one, put in the book. So if you have a child and the child has a handicap or some kind of a problem, the school board has to give him special lessons and try and deal with it. And if you, the parent, think the school board's doing a bad job, you can sue them. And if you win, they have to change how they do it, but also it says in, these were the words in the case, it says that you, the parent, the winner in the court, are entitled to your costs. And the question was, what costs? The woman involved said, I paid $29,000 to an educational expert. Do I get that money? Maybe not. Or maybe it's just the cost of the filing fee. Or maybe it's the lawyer's fee. And I say, Nino, what am I supposed to do here? Just read the word costs? All right, I'll read it. You know what it says? Costs. Oh, wait, I get it. I didn't read it enough. Okay, I'll read it more. Costs, costs, costs. You mean I didn't pay enough attention to it? Okay, I'll do it. Costs. So, what do you want me to do, Nino? And that's the easiest one I could find. What about, you can sue the government. I shouldn't tell you that, but you can sue the government for an awful lot of things if they hurt you in various ways. But there's some exceptions. And one of the exceptions that you can't bring a lawsuit for is a customs or excise officer, it says. You cannot sue them. They're immune for property of yours they might have or whatever. Customs or excise officers, or, now here are the words, any other law enforcement officer. Okay? Problem for us in the court? Does that include traffic cops? Does that include every ordinary policeman? If so, there are 100,000 stuck into this immunity box. And no one said a word about it in the Congress when they wrote this statute. So I'm not going to do that. I'm not going to say, this tells us in the words. I'm going to look for a few other things too, which I did. But you get the idea?
Yes.
Yeah, okay.
I didn't mean to shut you up. I'm just saying yes.
No. If you have the idea, that's more than that's great.
Does everyone have the idea out there too? Yes, okay. We're moving on. Now I'm sure that many people will want to talk to you about specific modern cases, like the ones you either dissented on or had views on, like the free speech issues, Dobbs, Bush versus Gore, Citizens United.
So Dobbs, I'll tell you one thing about Dobbs, that when I wrote a dissent in Dobbs with the help, and we put it together, Elena Kagan and Sonia Sotomayor. And Dobbs is the abortion case, in case you do, and we were pretty unhappy about that. But one of the most interesting parts about Dobbs, if you remember the four promises, the fourth promise, which I think for many of the textualists is the most important, the fourth promise was, and they won't be able to substitute their own views of what's good or bad for the words on the paper, for the law. Yeah, okay. Sounds good. I mean, it sounds just wonderful. But a little less wonderful than you might think. Why? Dobbs. Now let's imagine, see, Dobbs, in case some of you won't know, Dobbs is the case where they overruled Roe versus Wade. All right, now I put Mr. Textualist up here. And I say, Mr. Textualist, now you overruled Roe versus Wade. Why did you overrule Roe versus Wade? Is it that, let's see, that they didn't decide, Harry Blackman, when he wrote it, didn't decide Roe versus Wade according to the textualist or originalist theory? No, he's going to say no to that. That isn't the reason. That can't be the reason. It can't be the reason. That can't be the reason because hardly any cases were decided by textualist or originalist methods before the middle of the 20th, end of the 20th century, really. So we put everything up for grabs. And your client would come in to you, the lawyer, and say, I want to do X, and you'd say that's illegal. He'd say, well, it doesn't matter. We'll just tell him to change it. See, so they'll say, no, that isn't the reason. I'd say, okay, it isn't the reason that you overruled it, that they didn't use textualism or originalism. Well, what is the reason? I know what it is because you said it. That it's very, very wrong. Egregiously wrong were the words in the opinion. Ah, I say, now I understand. You felt you could overrule that because you thought it was egregiously wrong, very wrong. But you think that I might substitute what I think is bad or good for the law. But when you decide something is wrong rather than right, you couldn't substitute something that you think is wrong or right for the law? Now he's going to have a hard time with that because it seems to me they're equally open. And if they're equally open, goodbye to the fourth promise. The promise that it will help us prevent judges. Judges, if they're doing a decent job, don't. Or will do their best not to substitute what they happen to think is good or bad for the law. They can't always succeed. I've had the life I've had. I was born in San Francisco. I grew up there. I went to public schools. My father was the lawyer for the school board. His watch, it says on his watch, Irving Breyer, 1933, 1973, legal advisor, San Francisco Unified School District. That was my life when I was a child. And we've all had the lives we've had. And you can't escape them entirely, but we can try. We can try if we're trying to get the right result under the law, to do the best we can, to not make it a personal thing. And I used to think how terrible that everybody should agree with me. Who's so nice. But I began to think a little more maturely after a while on the court, and I began to think this is a big country, you know. There are 330 million people, I've said that. My mother used to say, there's no view so nutty that there isn't someone who doesn't hold it in this country. And then we were in San Francisco. She added, they all live in Los Angeles. But nonetheless, you see the point. It's not such a terrible thing having on this court people who have different views and who are from different places and have different backgrounds. And I learned that after a while, and I would stick to that. I'd stick to it. But what I don't see are those four promises.
Can you enumerate those quickly for us?
One, that this is easy.
And then I have a lot of other questions.
This is easy. Really? Really? That cost thing was easy? Or the other one was easy? 2, it'll be the same across the country. Why? Why do you think that'll happen?
Those, yes, right.
3, that the Congress will be so happy because they'll know what's going to happen to their statute. How will they know more than any other system? I don't see it. And 4, will stop the judges from substituting their own views for the law. And I don't see how that's one whit more true than if you were the greatest textualist, originalist in the world, because you're going to overrule if you want to do that, which might not be the right thing, but do overrule those things you think are wrong. And if you think are right or wrong, there you have it, right there, the opening to put in what you think are right or wrong instead of, quote, the law. Now, you have at least my side of what we used to do when Nino and I would talk. And when we were at Lubbock, that was great. It was fun. We were in the football field because the students, lots of students were there. They must have thought there was a football game going on. But they enjoyed it, and we enjoyed it. And they saw people can have different views, and even though they can have different views, they can be friendly. They can be friends, and they can like each other and listen to each other.
Okay, now I'm going to jump to the present, if you don't mind, because we don't have that much time, and I really want to hit some of the other things, even though this is all fascinating. I want to ask you what presidents from the past have tried to defy federal court rulings. I know what presidents from the past have defied federal court rulings, and from that I want to move on to the present. Of course, I know the only one I know of is Andrew Jackson.
That's the only one I know, and it's not clear. I mean, what happened in that case, that was in the 1830s. The Cherokee Indians had a treaty, and they owned northern Georgia. But they found gold in northern Georgia, and the Georgians thought, why should the Cherokees have it? Why shouldn't we have it? So they marched in and eradicated all the Cherokee law and put Georgian law in, and a missionary from Massachusetts named Worcester went down there, and they arrested him and threw him in a Georgian jail, and he got a lawyer. The Cherokees got a lawyer from him. I mean, they were a very, actually, modern-day terminology, civilized group, those Cherokees. And what does a civilized person do when he's in trouble? He gets a lawyer. And they got the best lawyer of the day, Willard Wirtz, who became Attorney General. And he went to the Supreme Court. He won. Of course he won. The Supreme Court said this land belongs to the Indians. It doesn't belong to the Georgians. Yeah. And Andrew Jackson, supposedly, he said something like, because the actual words were made up much later by Horace Greeley. He said something like, John Marshall has made his decision, now let him enforce it. And Marshall wrote to Story and said, I fear that the Constitution is finished. Mm-hmm. But, very soon thereafter, he was telling the Georgians, I believe, don't let Worcester out of jail. In South Carolina, they heard about all that, and they said, hey, this is a great idea. We owe the federal government a lot of money, customs duties, etc. Let's not pay it. And they didn't. And suddenly Jackson thought, maybe this was not the brilliant idea that I thought it was the first time. And Worcester was let out of jail. So did the law prevail? Well, hard to say, because what Jackson did next was send the army to Georgia, and they evicted the Indians who went along the Trail of Tears to Oklahoma, where their descendants live to this day. And interestingly enough, I put the picture in the book, the wife of Chief Ross of the Cherokees. Chief Ross was a genius. He was a brilliant man. His wife died on the Trail of Tears, and she is buried 1 mile from Little Rock High School. Amazing.
Yes.
Little Rock High School, the greatest symbol of the law will be followed. I mean, we all know, many of us know that. Not everybody's old enough to remember it, but I can remember it.
Me too.
Should I say it?
If quickly, yes, please.
Okay, quickly.
I'm sorry to impose that on you, but...
You know what happened after Brown versus Board of Education, 1954? Nothing. 55, nothing. 56, nothing. Double nothing. 57, a judge in Little Rock said, put the Little Rock 9, very brave 9 black children, into Central High School, which is a white school, and they came up that September of 1957, and Governor Falvas had surrounded the building, White Citizens Council, and the militia, and he said, you may have a court order, but I have the state militia. Mm-hmm. And that's when Hayes Brooks, the congressman, arranged for him to see Eisenhower, and Eisenhower was counseled by one person, don't do anything because you'll have to fight another civil war. But Brownell His attorney general said, you've got to do something because the rule of law is at stake. And he did. Some of us remember that. I hope all of us would. The 101st Airborne went from Fort Bragg, 1,000 of them, went to Little Rock, took those children by the hand. Took those children by the hand and walked them into that school. But they couldn't stay forever. And when they left, the school board tried to undo integration. He went to the Supreme Court again. Supreme Court said, integrate. 9 people. I told this to the woman who's the Chief Justice of Ghana, who's asked me the question, why do people do what you say on the court? And I had to tell her these stories, because it's stories, and it's mood, and it's history, and it's getting used to the thing. And by the time that the school board again tried to work with segregation and stop integration, that was the day of Martin Luther King. That was the days of Rosa Parks. Those were the days of the Freedom Riders. Those were the days when the North awakened to a big problem in segregation in the South. And they couldn't withstand that. And the point I'm trying to make to the woman who is the Chief Justice of Ghana, the point I'm trying to make is you want the rule of law, you have to talk to those 229 million Americans who are not lawyers. By the way, in Ghana, go to the villages, go to the towns, go to the cities, and have the lawyers do the same. And explain why you might want a nation where people will follow judicial decisions and laws written on paper, even if they don't like them, even if they think they're wrong. And very often those judicial decisions, I don't say very often, that's not fair, but every so often, they are wrong. Okay? That's why they're dissents. But do you see the point? And what I tell the students at Stanford when I go through this, and I say, I know 30% of you are thinking, oh, there should be riots and so forth. I say, fine, turn on your television set and go look and see how countries run, where that's the way they decide things. You might begin to think there is something to a rule of law.
Thank you very much. That was a very eloquent answer. Well, you can see your audience is behind you, and that leads very naturally into a contemporary question, which is the case of the Salvadoran Kilmar Abrego Garcia, who was deported by the administration, and the Supreme Court, the relevant officials were subsequently ordered by the Supreme Court to facilitate his return.
The Supreme Court had heard it yet, has it?
Oh, I thought it had. Wasn't it?
No, I think what happened was the lower courts
Sorry if I'm
did
wrong.
something, and then one of the parties, I think it was the government, asked the Supreme Court to take the case, and then the Supreme Court said no. I think that's what happened. We won't take it. You will know it better than I, but I'm not totally
well, the case,
sure of my facts.
I think the situation is still the same, though, which is that he was then subsequently visited by Senator...
They have a district judge, and the district judge has power to...
But apparently, this is the thing. This is where I'm getting worried, and I think many people in the audience are getting worried. I think in a recent conversation, I'm sorry if I got the bit about the Supreme Court wrong, but certainly there was no attempt to do what the federal court had said, and they have, and you said, I think on the 21st of April in a conversation, that it would be possible to hold the officials of the administration in criminal contempt. Is that right? Marco Rubio and
what
some of the others.
What happens quite often, which is very surprising perhaps to some, but shouldn't be surprising, is in every case, or almost every case, one person wins and one person loses. What does the loser think of the judge? He thinks the judge has made a mistake. And not surprising, since he also thinks the judge is an idiot, but he doesn't say that. What does the winner think of the judge? He doesn't think about the judge, he just thinks he's a good lawyer. But what the loser can do, and very often does do, is you appeal. And if you don't like the decision of the next higher court, you appeal that. And you can come to the Supreme Court. And if you come to the Supreme Court and they say, this is what the final thing is, this is what it is, that's what it is under the law. So I didn't think that we're there yet. I think I would have noticed if they'd had that case in the Supreme Court.
Well, I'm sorry if I made an error there.
I don't know. Maybe they have and I haven't. I do not notice everything, and I've discovered as I get older, that statement, I do not notice everything, has more and more of a ring of truth about it.
Well, I sympathize with that totally. But still, I think many of us are very worried about the state of the Constitution today. And I just wanted to say that the New York Times recently reported that the current president has written, that was then, since he writes an executive order every 5 minutes, I'm sure my count is wrong, but he's written something like 143 executive orders in his first 100 days, while only 5 statutes have been enacted by Congress, again, enhancing the power of the executive branch, it seems. And many Americans...
Did the Times say whether all those 105 orders were lawful?
Well, that's another question, which I'm sure...
Another question?
Sorry. Well, can I finish this one, and then please answer as you would like to.
Sorry.
I just want to get this part out, if you don't mind. I think many Americans have thought of the Constitution as a stable, steady assurance of the survival of our Union and its 3 branches, but many of us, including me, have, and I'd love to be dissuaded, have come to think that until now our system has depended on a general unspoken agreement based on trust and even honor. And if that goes, how can the judiciary function?
We have had a civil war.
Well, indeed.
During that civil war, I mean, this country, Kennedy used
I was going to ask you about that too. We don't time.
The country goes like this, you know. And during that period, just before the Civil War, I just heard the other day, if I remember correctly, there were 54 senators beaten up on the floor of the Senate. Remember Bully Brooks and Senator Sumner?
Senator Sumner was really
state?
hurt, yeah.
Yes. The country has been through slavery, a civil war, segregation, Reconstruction, I mean, all kinds of things. And what Lincoln said, I see Joanne, I'll tell them that in a second. What Washington said, what others have said, Lincoln said it in the second sentence of the Gettysburg Address. And Joanna said that our grandchildren will get $20 if they memorize the Gettysburg Address. And most of them did. 77 years ago, our fathers brought forth upon this continent a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. We are now engaged in a great war to see whether this nation or any nation so conceived and so dedicated can long endure. In other words, he thinks just what George Washington wrote to one of his friends, this is an experiment. We are an experiment, this document. We can't be sure it will work, but that's exactly what I say. Some of the high school students that I'll talk to, they'll look at me and say, well, what should we do about it? I say, my friends, this is yours now. This is yours. And you have to be the ones who will decide whether this experiment works or doesn't. Is that important? Yes. Could hardly be more important. And so if you're worried, find people who don't agree with you. That's what Kennedy would have said. Find some who don't agree with you and talk to them. Oh, wait, don't talk too much, he would say. Listen. And if you listen long enough, they'll say something you actually do agree with. And when they say that, you say, good. That's a very good point that you made. Let's see if we can work with that. And not always, but sometimes you're able to get somewhere. And Kennedy would say, if you get 30%, take it. Don't hold out for 100% so all your normal followers say what a genius you are when you got nothing. And that's the way he would do it. And I saw him many, many times. The reporter says, Senator Kennedy, you did so well on that bill. And he would say, don't thank me. Thank Orrin Hatch, the Republican. Okay? I heard him say that quite a lot. And so what he's doing with his staff, of which I was one and I loved it, I really loved it, he's saying to the staff, don't go around looking for credit what a genius you are. There'll be plenty of credit if it's good, and who wants the credit if it's bad? You try and get the thing through or stop what you're trying to stop, and you do that by listening and talking to people. And that's what I tell the high school students. And what makes me a little optimistic when I tell them that, not those words, not the words I just said, but all of a sudden, they are no longer at the window. All of a sudden, they're back in their seats. And maybe I'm making it up, but when I look in their eyes, I see interest. I see they're interested in that. I see that they're interested in finding out something maybe they can do, or maybe they can think of some other things too. And as long as those high school students or even the 7th grader have that look in their eye, I become somewhat optimistic.
Well, you answered my question about optimism. Does that make all of you feel a little more optimistic too? I'm not sure for myself, even though you were very eloquent, but that's another question. Well, we're almost at the end of our time. There was a study from, I'm just going to ask this and then one more thing. Maybe I'll ask the lighter one first, and then we'll get to the other one or not. This is the kind of lighter question. Have you regretted any positions that you've taken, or have you ever changed your mind on anything?
Oh, yes, of course. I mean, well, I learned a lot from Sandra O'Connor. She was great. And she said there are a lot of unwritten rules in the court. One of the unwritten rules is in conference, nobody speaks twice till everybody's spoken once. Very good rule for a small group. And another, very good. And another, and I was junior. I was the junior person last for 11 years. I almost held the world's record. Story had it by 11 days. I thought of writing to Sam Alito and saying, can't you just wait 12 days to be sworn in, and then I will go down in history as a trivia question answer. Okay. The other rule is tomorrow is another day. We were great friends on case 1, and we worked together to try to get a majority. Case 2 comes along, we have opposite views. That's okay. That's okay, as though they're different legally. And so what you tend to do is yesterday was yesterday. Do I know cases? I think, I'm sort of sorry I went along with a case involving, it's a technical thing involving cross-examination of witnesses. And I became convinced later I shouldn't have gone that direction. I think I did go. But people ask, do you decide cases that you don't really believe in? I wrote a pretty long opinion about why we should reconsider the death penalty. I did not get a majority, all right, but I have voted for the death penalty in many, many cases that follow, because I didn't get it. I mean, I didn't get my majority, and maybe someday they will. But that happens. You know, you have coming up in a year, you might have 4,000 or 5,000 cases asking us to hear the case, and we'll hear about maybe 50 or 60 or 70. You see, so there'll be a lot of cases out there that you would rather see it go the other way, but you can't really take it. They're just, it's not a big enough deal in terms of differences of opinion, et cetera, to take the case. And I just read the history of Holmes in the Taft court, and it was much more common then than it is now. But Holmes and Brandeis, who were there with Taft, would quite often say, I don't agree with this opinion, but I'm not going to write a dissent, because they wanted people to see a more uniform view of the Supreme Court. So, sure, there are 9 people. They don't all think the same thing, as you've noticed. And don't try to be the person who's always right. I mean, you want to know that in your mind when you're looking at it, but you're working in an institution, and you're working in an institution that's important to America. And so try to work with these 9 people. You're in that conference, it goes around. I mean, please, when it's your turn to say something, you say something and people notice this immediately. You say something that really means, ha, 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 I have a better argument than you. You think that's going to get you the vote? Don't kid yourself. All that will happen is that that person will then think when it's his turn to speak, ha, 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 I have a better argument than you. That gets you nowhere. The key, in my opinion, in that conference is listen. Listen to what the other people are saying. And then try to figure out, how can we get somewhere with these 9 people? How? And you're not sure, and you might try different things, and you've listened, and you try this, or you might try that, or the other things, and that has a better chance of producing not the perfect opinion, but one that's reasonably okay. And if you shoot for that, you have a better chance, and I think that's what you must do in a court of 9 people.
Well, thank you for that. We are just about at time. I had one more question, but I'll leave that for now so we can hear from the audience. And we're going to do something quite unusual, given that we have such a large crowd here. I'm going to call, these are the only people who will be addressing the justice directly. I'm going to call on some young people who will ask their questions in person. But as many of you have already done, we'll ask you, or we have asked you, to write your questions on index cards that my colleagues have collected from you, or can still collect if you need that. They're going to sort the main ones out, and we'll ask them on the collective behalf at one of the microphones in the hall. And I should alert you, and again, please correct me if I'm wrong, Justice Breyer, the Justice won't answer questions on current cases before the Supreme Court. That's right, isn't it? On the justices themselves, that is, their personalities or characters, or on politics.
No, I'm happy to.
Are you going to gossip?
Of course, we get on well. That's what people do not understand. I have never, in that conference room, heard a voice raised in anger. I have never heard one judge say something rude, not even as a joke or insulting, about another judge. It's professional. It's professional. We've read the briefs, we've heard the oral argument, we've discussed it with our clerks, and possibly we've discussed it with one or more of the judges too. This is a professional organization. It proceeds along those lines. And you read the newspaper, you might not know that. But I've seen that in 28 years and nothing else.
Okay. I thought you were saying we could gossip, but you didn't say that. So, and on politics in general. So keep that in mind in your questions. And now I'm going to ask, we have a troop of Girl Scouts, 7th grade Girl Scouts, who are going to ask a couple of questions. And I thought you would be particularly interested, Justice Breyer, because you were an Eagle Scout yourself, and I believe are still.
But I wasn't a Girl Scout, actually.
Did I say that? I wasn't accusing you of that. So, young lady, would you like to say who you are and whom you represent in the Scout troop, and ask your question?
Good evening, Justice Breyer. My name is Gia Breithatha, and I'm a 7th grader in Lexington Girl Scout Troop 67318. When I grew up, I aspired to be a lawyer. My question for you today is, what advice do you have for our generation on how to deal with the problems faced by both our country and humanity as a whole?
That is a very, very good question. And I can't do better than what I said before, when I was talking to the class. And you pay attention. And I certainly hope you're going to vote when you're old enough to vote. I can't tell easily whether you are or not. And good. And I hope you participate in public life. I hope you participate. You can participate in 100 different ways. You could be on the school board. You could be on the library commission. You could organize people to come and give lectures. You could do all kinds of things. But don't just sit there. And the meanest way to put what I just said, I read in a book by Derek Bach, and he said that in Athens, I guess 2,000 years ago or so, there was a famous speech given by Pericles. And he gave a speech to all the Athenians, and he was saying, what's so good about Athens? And he listed a lot of things like democracy and all kinds of things. There were a few bad things too. But he said, what do we say in Athens about the man who does not participate in public life? We do not say he is a man who minds his own business. We say he is a man who has no business here. Tough. Tough.
Good answer.
Thank you, Justice.
So get out there, and I can't tell you exactly, but it'll come. It'll come.
Now we have a second question
Yes.
from a Girl Scout.
Good evening, Justice Breyer. My name is Disha Mane, and I am 13 years old. I am a Girl Scout from Lexington Troop number 67318, and I aim to be a lawyer when I grow up. My question for you is, if you could go back to give your 13-year-old self advice, what would you say?
I like being 13, actually. I just started high school. Are you there yet? It was great. It was fun. There was, I had friends. You know, not everyone likes high school. That's all right. But I did. And so, what my father advised me, he said, do the job you're given. Do it as well as you can. Pay attention to other people, but do it. And if you do it well, someone might notice. And if they notice, they might give you a better job. But they might not notice. And if they don't notice, well, at least you've done that job well. That was his second most important advice. You know what his first was? You don't, because you didn't know him. You'd have liked him. But his first advice was stay on the payroll.
Thank you, Justice. And I have just one more quick question. Do you have a favorite Girl Scout cookie flavor?
I probably did, because my aunt was in charge of a Girl Scout troop. And I remember some of the Girl Scouts in her troop coming to the door to sell us, me and my brother and my father and my mother, Girl Scout cookies. And I must have chosen something.
Well,
Thank you.
and now we're going to talk. I think you may get some Girl Scout cookies out of all this. That's the only remuneration you're going to get. So now we're going to move to, we have a group of high school and college students also in the balcony, and I think a couple of them have questions as well. Is that Kunal there?
Yes.
Could you please stand up and identify yourselves and what college or high school you're associated with?
Thank you, Rita and Justice Breyer. I'm Kunal Botla. I'm an undergrad at Tufts University and a member of Lexington's town meeting. We're in a state of flux at the moment. This town celebrated the 250th anniversary of the battles that led to the creation of this nation and the kind of creation of all the fundamental systems that we're talking about. But recently at Tufts, and a lot of, across the country, people are fearing kind of the rhetoric and the language coming from this White House. At Tufts, a graduate student was taken off of the street and detained seemingly because she co-authored an op-ed in the Tufts Daily, a publication I also write for. And at Tufts, this is being seen as the start of a degradation of our First Amendment rights, particularly around the freedom of speech and of the press. To what extent do you believe that the detainment of students across the country, and this particular student, is a signaling of a loss of rights in this country?
No, I mean, we're not there yet. We're not there yet. We're not there yet. We still have this Constitution. We still have courts to say what is what. Even the president said that he would follow the Supreme Court. And the woman, who I saw that too. You think that affects me too, you know. And what I think is that good, what you're doing is talk about it. Listen to people. Get people together. Don't just sit around and, you do your best to try to figure out how will we convince people. Maybe there's some who don't agree with you. Well, see what they think. And maybe you'll end up convincing them that maybe this was unfortunate. I mean, we have a country. Go read that First Amendment. You mentioned it. I think it's just great. Why? Not because it's called the First. I read this in a book that Bert Newborn wrote. It's called The Music of the First Amendment. And if you read it with what he said in mind, you see something here. There's something interesting here. Not everybody sees immediately. Here it is. Amendment 1. Show you something. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, you have to give me a little bit of leeway here, because I tend to think, perhaps wrongly, but I tend to think that in the 18th century, people who were thinking politically, people who were thinking about how the country should be, a lot of them were religious, and religion had a lot to do with it. So you can, without too much stretching, take that first phrase as saying, you, like me and like everybody here, are free to think what you want. Okay? Whatever you want, think it. Next one. Or abridging the freedom of speech. Now, you've thought something, you can say it. Now, not everybody should say it because it may not be the most brilliant thing in the world, but if you want to say it, you're free to say it. Or of the press. And if it seems to catch on, the press can spread that word that you thought of and then spoke throughout the country, so a lot of people hear it. Or the right of the people peaceably to assemble. So we can get together and we can discuss it. And we can say whether that idea or a related idea or some other idea is a good idea or a bad one, and people will have different views of that, but that's called public opinion. And it develops in that way, out of those four things, and to petition the government for a redress of grievances. You see the point of developing that public opinion through thought, speech, press, discussion, is to transmit it to those people whom we have elected to carry out our views or what they think is best for the country in Congress. So you have right there, first thing in that First Amendment, a way of making a democracy where the people are actually pretty much in charge of making that democracy work. So you find people who think what you think is so bad is good. I don't know anybody. I mean, it seems to me pretty hard. But if they're arguing with you, read them that. Read them that.
Can I ask a brief follow-up?
Well, Kuna, I'm looking at the time. Was there someone else who also wanted to ask a question? Should we give a chance? Because I want to have a chance for the audience as well.
Sure. Hi, Justice Breyer. My name is Nidhi. I'm a senior here at Lexington High School. I actually ended up reading your book for one of my projects in government. And one of my questions that I had for you is, I know in the book you talk about the importance of a purpose-oriented approach. And at the same time, you also concede that judges must rely on what you call, quote-unquote, judicial instinct, saying that there is sort of leeway and there is room for a judge to insert what they think, based on their own instinct, should be used in determining what a decision should be. And my question is, I'm sure you know, public opinion of the Supreme Court at this moment is low. People think it's unanswerable to the public, and people think that it's undemocratic. And so my question for you is, how do you respond to critics who may say that, quote-unquote, the judicial instinct argument is feeding into that? And as a follow-up, I think the broader question I'm trying to ask is, do you believe that the Supreme Court is a democratic institution?
No.
And if not,
no,
do you
it's
believe,
not democratic.
do you believe it? Do you believe it ever can be?
No, you don't want. You want a person who is trying a criminal, who is unpopular, to be looking over his shoulder at public opinion about that unpopular person? The answer to that question is no, of course not. You want a fair trial for that person, even if he's the least popular in the United States. But, you can't be totally unaware of it. The statement that I've found that is the best statement on the subject you raised, which is a difficult, important, and interesting subject, was Paul Freund, who used to teach at Harvard, constitutional law, brilliant con law professor. And he said, no judge, he's talking about politics in the court, and he's saying no judge will decide a case based on the temperature of the day. But every judge is aware of the climate of the era. You see? Were that not so, we would still be back at Congress can't pass minimum wage laws. Or we'd be back, we never would have had Brown versus Board, perhaps. You see? So what is it like? That's the hardest question I have to answer. And I say, well, I told you Paul Freund's statement. It's a good statement, and one of the virtues is no one knows what it means. But it's sort of like this. is there politics? There's politics in the sense that when there's a vacancy, every political group in the country wants to tell the president whom to appoint. But the person who is appointed, when he decides a case, doesn't think he's doing so on a political basis. He thinks he's doing so because that's what the law demands. And you have that difference throughout. And you say, well, never? Well, what about Justice Frankfurter? At the time, just after Brown, when a case came up on miscegenation, interracial marriage, and the court was going to hold, certainly, that that was unconstitutional. What? Forbidding it was unconstitutional. If people wanted to marry someone of a different race, that's up to them. Frankfurter knew that's what the court would hold, and they'd have to hold it. And what he said to the conference was, I think we better not take this now. Nobody's following Brown. We're having a terribly hard time getting it enforced. And if we decide this now the way we're going to decide it, we'll never get it enforced. We'll never get Brown enforced, and there'll be segregation in the South. The court agreed with him. They didn't take it. They took it 2 or 3 years later, and they decided just what I said, that people of different races must be allowed to marry. But you see, that's politics. That was politics about how we're going to get Brown enforced. And when I was a law clerk in 1964, 65, the court was still worried when I worked for Justice Goldberg. I thought it was, and all of us, the clerks thought that, and probably the judges, this is a court with a mission. And the mission is getting Brown versus Board of Education enforced. Okay? So you can't say, I usually say if I want to be funny, it's not that funny, but I say, do you ever read P.G. Wodehouse? P.G. Wodehouse is funny, I'm not, but he is. And he says in one of his books, he says, Bertie, his hero, got up one morning, and he wasn't disgruntled, but he wasn't exactly gruntled either. So I say, that's the best I can do on politics in the court. If somebody thinks it's politics like working for Senator Kennedy, they are wrong. I'm in Senator Kennedy's office, and the Secretary of Defense calls, and the Mayor of Worcester calls, and he has to decide what call to take first. That's the easiest question there is. He'll take the Mayor of Worcester first. That's where the constituents are. You see? That's politics. How do we get the Republicans to come to the exec? How do we get, that's politics. That's not the Supreme Court. That was not the Supreme Court for the 28 years I was there, and I doubt that it's the Supreme Court now. All right?
Okay, I see we're ready at 9 o'clock, and I want to be sure we can ask some of the questions from the audience, but I'm going to ask you we're going to have some peculiar conditions today because of the crowd, really. I'm going to ask, when we conclude the question period, which we hope to have for at least 10 or 15 minutes more, and then you'll have to sign a lot of books in a hurry, because we're hoping to give you a whole half hour. When we conclude the talk and question period, I'd like to ask you all a favor. Please don't come up to the stage in the hope of engaging the justice in private conversation. We'd like, because it's going to be a mob scene, we'd like to avoid crowds so that we can bring him out to the lobby where he'll sign copies of his book, which we have for sale. And even then, please don't engage the justice in lengthy conversation. We want everyone to have a chance to have their book signed. And we have a firm stopping point at 9:30, which is why I'm concerned about the questions. Can you all promise you'll do that? That would help us all and help the justice. Thank you very much. And now let's have some of the questions.
So there's a couple of questions. How has textualism been used to overturn gun laws across the country? How does textualism versus pragmatism, how has textualism been used to overturn gun laws across the country? How does it apply to the Second Amendment?
Okay, the gun laws. I wrote a long dissent on that, I wrote a long dissent in that case, and when you have trouble sleeping, I recommend it to you. But Clarence Thomas wrote the opinion for the court, and his view was, let's go back to the time the amendment was passed, the time that the Second Amendment was passed, 87 or 89 or whatever, and let's see what people would have thought that that meant at that time. And Nino had written the Heller case, and the Heller case, he said the same thing. And a majority went for that. I was in the dissent in both cases. That's why I recommend the dissent to you. But regardless, I think actually textualism didn't help either side very much there, because the argument against Clarence, he said that's what they meant. They meant you could have a gun under your pillow to stop robbers. The right to bear arms. I thought that isn't what they meant. And I found a case, actually, I found some law in Massachusetts where people couldn't have ammunition in their houses at night. I thought that was a great point. Didn't convince him, though. All right. But the argument the other way was also a kind of a textualist argument. It was that a lot of people, as you know, were against having a constitution. And one of the arguments that they made was the first article says that Congress can call up the militia and regulate them. And so the Congress might, if we pass this, call up the state militias, regulate them, and disperse them. And you wouldn't have those militias that just beat the British. So Madison is sitting there and he says, I can deal with that. I'll write an amendment which makes certain that you cannot disperse the state militias. You can't get rid of them. And that's what he meant by the Second Amendment. Well, John Stevens wrote that out in quite a few pages that are better than I've just repeated it. But both sides were saying they meant different things at the time of the writing of the Constitution and the Bill of Rights.
But I think this person is asking, what are the dangers of using that approach in terms of guns in this country and rising violence?
Well, we don't know where
right?
it'll go. What guns are going to have, what not. I happen to be reading a British judge who retired named Sumption wrote a 5-volume, 800 pages each about history of the 100 Years' War, which I've been reading. Don't ask me why. But I knew a lot, so I put in the opinion. And what does it mean that in the 100 Years' War, that was Sumption. It's a good book. It's a pretty good book. He said that they used halberds and they used skull ladders and they used Asian fire thrown over the ramparts. I said, what is all that? What's the significance of all that? Well, I didn't expect to get an answer from Clarence on that, and I didn't. But so it'll be. But the most dangerous thing, in my opinion, in the court, I'll tell you, you're not going to believe this, but I do believe it. The most serious thing I got was not paying attention. Bill Clinton advised me, said this. He said, you will discover that the applause dies away much faster than you think. And then you are left with the job. So you better like it. And not taking that into account is a danger. I mean, in 2 years, I'm in some kind of thing in one of the reception rooms. A young lawyer comes up and says, oh, Justice Breyer, I think your opinions are so wonderful. Will you sign my programs? I say, sure, I sign it. So I sign it. He walks away. As he walks away, he turns to his friend and he says, that makes 4. Yeah, I understand. But the job is a very, not just interesting, but you have to take it, you take it seriously. You devote what you have. For 4 years, you think, can I do this? And then maybe after 3 to 5 years, Souter thought 3 years, Douglas thought 5 years. Can I do this? You think, well, I can do the best I can, and that's it. And the cases, each one, doesn't matter what case, it calls for you to give your best. And so the greatest danger that I could think of would be a danger of a judge not thinking that.
So there were a lot of questions about immigration, and one asked, do non-US citizens have a right to free speech?
Do what?
Non-US citizens.
Of course.
Okay. Can I ask you then, what's going on here now?
Thank you.
Was that the answer? Was
She
it-
said can't say free speech.
Oh,
What we're having.
okay.
Look, they started this
Okay,
in
I'm
New
sorry.
England. They started these town meetings. David Souter said the thing he liked better than being in Washington deciding all these cases was going to a town meeting up in Concord, New Hampshire.
Well, I'm in town meeting. It's not always that much fun, but anyway.
Oh, yeah, it's not supposed to be fun. It's supposed to
I
decide.
know, yeah. All right, so anyway.
Okay, I'm going to combine a couple questions here. So you were confirmed by a bipartisan vote of 87 to 9, which seems hard to even believe today. And a lot of people do feel that the court has become too politicized. Of the ideas being floated to reform the court and ensure its judicial independence, such as enlarging the court, term limits for justices, enforcing an ethics code, are there any you support? Why or why not?
I mean, I've said many times I don't see any problem really in having an age limit. Most courts do, as long as it's a long term. You don't want somebody, I mean, maybe it should be 18 years, maybe it should be 20 years, I don't know exactly. But then I wouldn't have had to worry about when do I retire. People wouldn't have to worry about that. I think that might be a good idea. But as they do in different countries, you want a long time because you don't want the person on the court thinking about what his next job is going to be. That's important. Of those you've listed, I mean, that's the one I've thought about the most.
Monica, do you think, and Meryl, both of you, do you think this should be the last question, given the time? Or do we have time for one more?
We probably collected 80, so I think this is the last question. So it's related to what we just asked. The Supreme Court adopted a code of conduct in 2023. How does this differ from a code of ethics?
It is a code of ethics, but the ethics, I mean, there are 7 volumes of ethical rules for judges. All the federal judges have those. I had them in my office when I was in the First Circuit, and I had them in my office when I was on the Supreme Court. If a question came up of whether I should recuse myself from a case, I would try to find the answer in those 7 volumes. And if I couldn't find the answer in the 7 volumes, I would call Gillers, who's a professor at, where is he? I think he's at NYU, or he's one of them. He's a very good, very knowledgeable on legal ethics. And I'd ask him his opinion. You say, is there a difference? The difference is this, and there is a difference. If I'm on the Court of Appeals, and something comes up that maybe I should recuse myself, and it's a close question, I might as well recuse myself. Why not? I save myself some criticism, and they can put someone in my place. And that judge can decide it just as I could decide it. If you're on the Supreme Court, there's no one to put in your place. And there are a lot of lawyers, and some of them, well, perhaps all of them, are not stupid. And they may think if I can get X recused from this case, I have a better chance of winning it. And so if you get an issue on the Supreme Court where maybe you should recuse yourself, you have to be careful. And you have to realize you have a duty to sit, as well as possibly a duty not to sit. And so you can ask your colleagues, which normally people do. You can look in those 7 volumes, which I'm sure, I know I did. I can't name everybody who does or doesn't. But there are ways of finding out what is the better thing, and then people make up their minds and they decide.
I think with that, am I right in thinking that we have concluded?
Yes, thank you. We have so many more questions, but we're not going to get to them.
Lovely. So I'm going to thank Justice Breyer again. And I really am sorry we didn't have time for more questions. You can see that it was a very rich conversation, and I hope you all enjoyed it. And now we will venture towards the lobby, and Justice Breyer will sign books if you're interested in buying them. Thank you very much.